So in chapter 19 for business law, we talked about um, breach of contract and remedies that happen or occur when a breach of contract happens. So basically, as the innocent party, when there is a breach of contract, you do have different options when it comes to that breach, and it can depend on the situation that you're in and the type of damages that were done to your business. So the different options include some of the most common ones are getting damages, rescission and restitution, specific performance, and reformation. So those are different types of relief for the innocent party when the other party breaches their contract or doesn't perform what they're supposed to do. So like I said before, it can depend on the situation and the type of damage that occurred. So the types of damages and situations where they apply. So there's four main categories four broad categories for damages. You have compensatory, consequential, punitive, and nominal. So compensatory covers direct losses and costs. Consequential covers indirect and foreseeable costs or losses. Punitive punishes and deters wrongdoing in an attempt to kind of prevent that, and so it doesn't happen again. And then you have nominal, which recognizes wrongdoing when no monetary loss is shown. So there are different situations that come along with those different types of damages. So for compensatory damages, an easy one is construction. You can have breach of the owner, breach of the contractor, or breach of both the owner and the contractor. So when it's just the owner, damages depend on whether the breach was before, during, or after construction was completed, which that will affect the remedies involved. Breach of contractor, the measure of damages is the cost of completion. So that's something that's very big. And then when it's a breach of both, the courts can attempt to strike a fair balance in rewarding damages. So there's different situations when it comes to compensatory damages. Sale of goods, for example, the difference between contract and the market price. Land or sale of land, specific performance, so on. Next we have consequential damages. This is something like foreseeable damages that result from a party's breach of contract. So if you have a contract and the other party breaches that contract, and as a result it's going to affect your business later on through sales or production or whatever, that's when consequential special damages can be applied. Punitive damages to punish future conduct. So a company does something and for like a business, like you can't throw a business in jail, so you're going to punish them through punitive damages so that they don't do that again. There's basically like you're going to hit them hard with the punitive damages. It's generally not available for a mere breach of contract. It's definitely specific situations when it comes to that. And then nominal damages, no financial loss. What is mitigation of damages, and what does it mean for the parties in the contract? Mitigation of damages, duty of innocent injured party to reduce the damages that he or she suffered. So duty depends on the nature of the contract. You have different types of contracts. You have your rental agreements. So basically, if you suffer like a breach of contract, you have to do what you can so you don't keep continuously making those losses. So rental agreements, if a tenant can't pay their rent or whatever, you have to try and find someone else to come in. You can't just keep getting hit by that. That's your duty for that. Non-monetary remedies. So basically, this is a protection available to trademark owners under basically to trademark owners. These include provable damages, attorney fees, corrective advertising costs, reasonable royalty, things like that. So that's basically everything about non-monetary remedies. And then what is a waiver of breach of contract, and what does it do in breach of contract situation? A waiver is like knowing relinquishment of a legal right to require satisfactory and full performance. So basically, when it comes down to it, you can waive a contract because breaches of contract are often waived to obtain whatever benefit is still possible out of the contract. So even though there may have been a breach of contract, there's still a lot more to gain from the rest of the contract. So if you trust that they'll finish that and they'll do the rest of their part, you can waive it because you're going to gain more out of that than you would from any remedies. So that's basically everything in Chapter 19.